Hello friends, in the series on the income tax cases, today we will discuss a very important judgment of the Honorable Supreme Court in the case of D.N. Singh versus Commissioner of Income Tax and another. This case has been reported in 454 ITR at page number 595 and the date of the judgment is 16th May 2023. This is a classic case on section 69A and it throws light on each and every aspect of section 69A. The facts of the case are very interesting. The judgment is very interesting. In this case, the assessee is a transporter. The job of the assessee is to pick a material named as bitumen from the oil companies and to deliver it to the various divisions of the Transport Department of Bihar. There was a report in the media that there is a scam going on for the delivery of this bitumen by the transporters by taking the delivery from the oil companies to the road transport department. Due to that report, the case of the assessee was picked for scrutiny and assessment was done under section 69A by alleging on assessee that the assessee has undisclosed income of near about 1 crore rupees in the form of this material bitumen. It was the contention of the assessee before the learned assessing officer that in section 69A, the prime condition is that the assessee should be the owner of money, bullion, jewellery or other valuable article. Because the assessee was only a transporter, though the assessee was not in any case the owner of the goods, so section 69A cannot be applied on the assessee. It was the summation of the assessee. But the learned assessing officer was not convinced with the assessee and the additions were made under section 69A. When the matter came before the CIT appeal, ITAT and the High Court, all this CIT appeal, ITAT and the High Court dismissed the appeal of the assessee. When this matter came to the Supreme Court said that the prime condition of the applicability of section 69A is that the assessee should be the owner of the goods, and in the present case the department was not able to establish that the assessee was the owner of the goods, because in this case the assessee was taking the delivery of the goods from the oil companies and was delivering these goods to the various divisions of the transport department. Even if the assessee is found in the possession of some illegal goods, like in this case, because these goods were basically related to the various divisions of the transport department. So the Supreme Court said that the department, without knowing that who is the owner of those goods, has made the addition in the name of the assessee, which is not as per the mandate of section 69A. And the another point of the Supreme Court was that the section 69A talks about money, bullion, jewelry or other valuable article. So by applying the principle of adjustum generis, the Supreme Court said that the bitumen, which was having a price of rupees 5 per kg relating to that assessment year for which the case of the assessee has been fixed, is very minimal. So the intention of the law cannot be to tax that low price item into section 69A. The Supreme Court also said that there is one circular of the department, circular number 20, which was issued in 1964 when section 69A was brought into the statute. According to that circular, it was clear that the purpose of introducing section 69A is to tax those people who bought gold, jewelry, bullion just to evade the payment of the tax and to use their black money. In that circular, it is also made clear that this section is not for the middle class people who inherit the jewelry from their forefathers. Friends, this circular is also very important, and in this case Supreme Court also discussed two more things. One thing was that the Supreme Court said that if there is no conveyance deed, then it cannot be said that the assessee is not the owner of the goods. For the purpose of determining whether an assessee is the owner of that money, bullion, jewelry, it is necessary that it is to be seen that whether the assessee is deriving income from that article. If the assessee is deriving income from that article, then it can be said that the assessee is the owner of the goods, even if there is no conveyance deed in the name of the assessee. In this case, the Supreme Court also said that the document of title, fixed deposit receipt also cannot come into the definition of other valuable article, because document of title and fixed deposit receipt cannot be bought and sold in the open market. So the message of the Supreme Court was very clear that for taxing under section 69A, only movable items can be taxed, only valuable articles can be taxed, immovable items cannot be taxed. Friends, this case is a classic case on section 69A. It is a worth reading case. I have tried my level best to summarize this case in 5 to 6 minutes, but I hope that everyone will read this judgment. At the end of this video, once again I am repeating the name of the case. The name of the case is D.N. Singh versus Commissioner of Income Tax and another. And this case has been reported in 454 ITR at page number 595. The matter has been decided by Supreme Court and the date of the judgment is 16th May 2023. Thank you, friends.